in Zimbabwe. I have experience working on children's rights from over 12 years, and currently I'm an independent consultant really working on a number of research pieces on the status of child rights in Africa. And I currently hold a master's in law on child justice in Africa from the University of Port Elizabeth. And it's such a pleasure to be on the call. Thank you so much.
Thank you so much, Yvonne. And then I'm going to go to Edmund.
Good afternoon. Thank you very much, Jenny, and warm greetings to everyone from the Gambia, where I am based, but I'm originally from Ghana. Edmund Foley, I'm the Director of Programs for the Institute for Human Rights and Development in Africa. Well, since 2005, thereabout, I've been working on children's rights, on the African human rights system in general, and I'm also a lawyer by profession. I've worked across civil society, government, and academia.
Thank you so much. Winfred? Winfred, you're muted.
Oh, thanks. Thank you, and good afternoon, members and colleagues. I'm called Winfred Adukule Moita. I'm an advocate of the High Court of Uganda, the founding member of Free Child Uganda, and the executive director. I specialize in access to justice for children in conflict with the law, and I'm based in Uganda. And it's a pleasure to meet some familiar faces again, and it's a pleasure to be here. Thank you.
Thank you so much. Yvonne, I'm sorry, not Yvonne, Katha.
Hi, everyone. My name is Nkatha Murungi. I'm the Assistant Director of the Center for Human Rights at University of Pretoria in South Africa. My background is law, so I'm an advocate of the High Court of Kenya, but currently, obviously, not based in Kenya, so I'm not practicing. I'm a researcher and trainer, lecturer in children's rights and more broadly human rights related to vulnerable groups. Yeah. Thank you.
Thank you, Katha. Elvis?
Hi, everyone. My name is Elvis Fokala. I studied a lot about children's rights, and I still write on children's rights. I do teach on children's rights as well. And I'm, at the moment, still very much focused and probably obsessed with child participation issues, and still continue with that. But yeah, that's my background, trained completely in law. And at the moment, I'm based in Stellenbosch, the University of Stellenbosch. Thank you.
And then Juliet.
Good afternoon, good morning. My name is Ruth Juliet Nyambura Gashanja. I am an advocate of the High Court of Kenya. I am the technical advisor to the NCAJ Special Task Force on Children Matters. I have worked on children issues since I was, I can say, a child myself. And yeah, I'm happy to be part of this panel. I'm also a lecturer at Kabarak University.
Thank you. So we have Teresa, but I'm going to let her not introduce herself now, but until after Rosalind has spoken. Oh yeah, Violet has joined us. Let Violet come introduce herself, and then we can. So Teresa, you're going to be introduced by Rosalind. Violet, switch on your camera and introduce yourself. But I understand if you don't switch on your camera, I understand the internet there is really bad. Violet?
Hi.
Hi. Go on.
How are you?
I'm fine.
Good.
Introduce yourself, Violet.
I'm Violet Odala. I'm the program manager for Children and the Law at African Child Policy Forum, based in Addis Ababa.
Thank you so much, Violet. Rosie? And then you can introduce Madam Teresa.
Good afternoon, everyone. My name is Rosalind Wambui Kabata. I'm an advocate of the High Court of Kenya. I'm interested in legal research and legislative drafting, and I'm happy that we are having this forum today. The objectives of this webinar are: one, to understand the formal and informal justice systems used to promote child justice in Africa, to learn about the alternative dispute resolution mechanisms used in African countries, to outline the aspects of a child-friendly justice system, to learn about the existing policies in African countries to enhance access to justice for children, to have an overview of the state of the child justice system in Africa towards actualizing access to justice for children, and to be informed and to borrow from the best practices in the child justice systems in other countries. And now I'd like to introduce the country manager to the International Development Law Organization, which has funded this webinar and supported the NCAJ Special Task Force on Children Matters. Teresa, you may have the floor.
Thank you very much, Rosalind, and good afternoon, everyone. I assume it's afternoon in Kenya at least. Thank you very much for putting together the webinar, of course, NCAJ, and gracious to speakers from all over the continent. I'm very pleased to see that this is really a regional discussion appropriately in commemoration of the Day of the African Child. The IDLO, some of you know, is an intergovernmental organization that's committed to advancing the rule of law. The approach really is to support facilitating access to justice for the most marginalized groups. Of course, children naturally fall into the group of those that are most marginalized. As a result, IDLO has been partnering with the judiciary and other partners, of course, in other programs across the world. We are in over 50 countries at the moment. But I want to speak to our work in Kenya, particularly supporting juvenile justice to just for children. We've been partnering very well with the National Council on the Administration of Justice, and that has seen us support a number of initiatives, I think, as Rosalind has spoken to. We continue to partner with the Task Force on Children Matters, and we believe that our support, no matter how small, I think, has prompted some developments that I think will see an increased access to justice for children, including, for example, court-annexed mediation that we have seen now being rolled out, children's courts in Tononoka, in Mombasa. We've also been working very closely with the task force on beginning to see how we can facilitate policies and reforms in guidelines for children in terms of accessing the courts, in terms of being diverted, I think, from the mainstream justice system. However, that is not my brief for this afternoon. My brief for this afternoon, I was asked to speak to, in the context of COVID-19, what do I see as the role of development partners to support access to child-friendly justice systems? And I think I want to speak to two things. I think the first one is that it's important for development partners like ourselves and others, obviously, to see how we can strengthen the capacity of court systems to be able to function primarily in a manner that, of course, takes into account the challenges presented by the pandemic, but specifically to be able to operate in a way that facilitates access to justice for the most marginalized, in particular children. I say this given that we have seen across the continent, and with reason, when we are facing a public health crisis, we have seen, I think, a scaling down of court operations, and the impact of that, particularly for access to justice for marginalized, that in fact justice has actually been limited or denied because a number of the cases have not been able to access the courtrooms because courts are not operating. So I think for me, a key issue that development partners should be looking at, and I think practitioners should be looking at, is how do we begin to strengthen justice systems, particularly the courts, to be able to facilitate justice for the most marginalized, particularly for children. So we are looking at issues around how do you create, for lack of a better word, virtual courtrooms, but also how do you facilitate access to those virtual courtrooms, because we also don't want to pretend that we live in Africa where everything works. So we all know the challenges that come, for example, with advocating for automation and online platforms in places where sometimes the internet is difficult, even for some of us to be able to participate in platforms like this. So that's the first area that I think is important to think about and to also reflect on. The second area that I'd like to reflect is how do we begin to support strategies that facilitate strengthening of support for children, and this is not just in the context of pandemic, but in the context of the pandemic, but broadly. So how do we support systems that support children that are in conflict with the law, that are in contact with the law, in ways that are inclusive, in ways that are respectful of their rights, but also in ways that ensure that justice is served? So for me, those are the two sort of critical areas where I would like to see a bit of reflection, if they are representatives of development partners on the, on the webinar this afternoon, and we can begin to talk a little more around how do we do that, so that we enable, justice to be served, to be seen to be done, and of course, justice to be done. So I think I'll stop there unless there are specific questions anyone would like me to address, and I'll be happy to engage in the. Thank you very much, Rosalind, and thank you to our moderator.
Thank you so much, Teresa. I really do appreciate your concern, and the fact that you are calling upon the development partners to do something about this, because a lot of children are not accessing justice during this COVID-19. So if you have any questions, Teresa is not going to be with us until the end. So because of that, we're going to have the first Q&A just for her, just for what she has presented. Any among our panelists and our attendees, if you have any questions to Teresa, please lift up your hand and you're going to allow you to talk. Okay, I can see one hand, two hands. Okay. Janet, go ahead. Janet, ask your question. Janet Motua.
Hello.
Yeah, go ahead, ask your question. Yes.
Thank you. I'm just following on a suggestion on support of strategies. In the broad perspective, or even in the pandemic. I'm just wondering what is a strategy she has in mind, if she can give some of us, because really currently we are experiencing these children are really not accessing justice at the moment of the pandemic, and more so in the rural areas. I live in the rural areas, I'm an advocate and I champion children's rights, but I'm noting a lot of children are not able to access. So I just want to pick her mind. What are these strategies she has in mind? If she can give us some, how it can work. Thank you.
Thank you, Janet. I think one of our speakers is going to be delving into details. So, okay. So I think by the end of the 2 hours that we have allocated for this webinar, we'll have responded to that question. So thank you so much. Christine Chepsang. Christine?
Yes.
Thank you.
Thank you for this opportunity, and also thank you for Teresa for the timely comment she has made in the beginning of this webinar. I'm based in Mombasa, and I like the fact that she has also mentioned that court-annexed mediation has taken root in Mombasa, which I can confirm is going on well. And she has talked of having virtual courtrooms. So I really wanted to understand how what she really thinks about, because what we want is to have as many children in Mombasa and the environs access justice, especially those children in conflict with the law. And tomorrow we have a CUC meeting, that is court users meeting, that is scheduled at around 10 o'clock. So I think this webinar is timely, and any points that I can get, I'll be able to share in that CUC because I'm a member. Thank you.
Thank you so much. Teresa, are you going to take any one of them?
Thank you very much. So two things, as I said, the points that I raised really are for us to reflect upon. I know that, and I call this the easy solution. A number of my legal colleagues, when we've been talking about the impact of the pandemic and access to justice, I think we've seen a preference and encouragement, I think, to use virtual courts. Let's use online platforms. And my question, which is the point that I raised, I think, in my remarks, was that while it's very good to think about accessing justice virtually, the reality is that that is not always possible. So as we reflect, how do we facilitate access to justice for the marginalized? Yes, it's very good to speak about virtual platforms, but also we need to be very practical about our realities. And our realities are that not everybody will be able to access virtual court. So for example, to Christine in Mombasa, you're saying that, you know, you are going into a CUC tomorrow. And one of the issues that, of course, you'll need to discuss is how do you ensure that children in conflict with the law are able to go through the judicial system as quickly as possible, because that's what we want for children, and get them off, you know, the criminal justice system. So the question for me becomes, how do we, if we cannot have court sitting, is there a way maybe we can engage the judicial system, begin to say, let's have special dispensations, special sittings for the courts, taking into account the health consideration, taking into account the fact that protective personal equipment is not always available. But how do we ensure that we are still able to get some sort of specialized courts that sit specifically to address children matters, that sit to address children matters in the context of the pandemic, taking into account the health considerations and ensuring that those that need to access the courts access them. And in instances where we can make use, I think, of virtual platforms, let's also think around how do we strengthen the capacity of the courts to do that? Because I think that there's also value there. But again, as I said, these really are points for us to reflect upon. I think to also push back with each other and really think more deeply around how do we make sure that the marginalized are actually able to access justice. So I hope that during the course of the discussion, if I'm still here, we'll be able to address some of those issues. But I know that they will be tackled by the very capable panelists we have this afternoon. Thank you very much.
Thank you so much, Sheresa. Thank you for joining us, and I know you're a very busy woman and just taking some time to come and speak to us. Thank you so much. We are also live on Facebook and Twitter and YouTube. If you are not able, or you know someone who is really struggling to join and they're not able to join, tell them to head up to the Mtoto News YouTube channel, that is Mtoto News TV/live, and then go to our Facebook page, Mtoto News Facebook, and also to the Africa CSO Forum page. We are also there. So I will go straight to our questions. So all you guys, I was telling you in the group that I'm a dropout of law school. I went to law school for, I think, 2 classes. I couldn't hack, guys. I couldn't do your own assert things. I said, no, my friend, I have other things I can do with my life. So you forgive my not very legalist language. So my first question, guys, goes to, I'll start with Elvis and Katha. What is justice? Elvis?
Yes.
Elvis?
Hear me? Should I switch off my camera as well?
Yes, please. Yes, please.
Fighting with bandwidth. So it's a medium that gives us the opportunity, in order to strike a balance between what is wrong and what is right. I'm trying to be as simplistic as I can, if I take into consideration what you just said before. But we hardly find children and under children's rights, children to have a right to access justice, albeit the fact that they are also required to get assistance from adults as well. I mean, if we look at the provisions in the Convention on the Right of the Child, and we look at the provisions in the African Children's Charter, they do allow children to access justice. These mediums where you can get some balance if you have been abused or maltreated and all of that. But it gives powers to the state. It mandates the state to enable this access, or to enable children to access justice fairly and equitably. That would be my contribution for now.
And Edmund, what is justice? Because you're talking about justice. What is this justice?
Jenny, it's quite a minefield, and of course, having taught the philosophy of law, I would do my best not to be tempted to go into philosophy. But simply put, let us say that when we talk of justice for anyone, then we are looking at the system within our communities that allows us to obtain redress when we are wronged by another member of the community, or where we also feel that we have been wronged by another person. We have the opportunity to seek redress and be compensated for that wrong. So that's about the simplest way in which I could put justice. But then also, justice doesn't only deal with wrongs, but it also facilitates our interaction as human beings. So for the layperson who often hears about justice, in the first scenario I talked about, getting a remedy for a wrong, then they think of the criminal justice system. Somebody has robbed me, and then I go take the person to a police station, he or she is put before court, and then I get a remedy or is put in prison. But there is also, of course, another side of justice which ensures that we are able to interact and live together. So in the context of our discussion for children, for instance, if a father and mother decide to separate from their union, it is this same justice system which ensures that that child is able to continue to live within the family environment. So it's not only about settling wrongs, but it's also about facilitating relationships in human society.
Nkatha, a professor of law, what does justice mean? Nkatha?
Yes, sorry. Given what Edmund has already said and what Elvis has said, I think I wouldn't want to stretch it further, because there is, of course, we can get into the technicalities of what justice is in the academic sense of the word. But I think one thing we cannot run away from, or one thing that we can all identify with, is that justice is as much about what it is not as it is about what it is. In the sense that when someone is wronged, they know they are wronged, even without having to go into the law and extrapolate what that actually means. So in most of the cases, we are talking about really just enabling people to have a sense of dignity, which is facilitated by knowing that they are protected by law, and that if someone does something against them, that protection is available to them simply because they're human. So that is the bottom line, that it is the mechanisms or the systems or the institutions, the collective that allows us as human beings to feel safe in the protection of the law. So if you take it further, you would say that to say that there is justice in our society, we are simply saying that every individual in that society, whether they are children, adults, whether they are persons with disabilities, whether they are people who are otherwise not in the mainstream of society, whoever they are in that society, has the same protection and the same benefit of the law. That is really what the collective justice would be.
Thank you, Nkatha. Before you leave, I came across this report, and you're talking about formal, informal, I don't know what other kind of justice system. Are you able to just give a difference? Because as I told you, I dropped out of law school first year. And at this moment, and I'm so sorry, I can see the UNCRC committee member, Anne Skelton. Thank you so much for joining us. I'm going to be allowing you to be part of the panel very shortly. But as I said, I dropped out of law school, and sometimes I have regrets, sometimes I don't have. So can you tell me, what is this formal or informal justice system?
Okay, so the formal informal definition is a definition that we make for practical reasons, and for also because the policies tend to make a differentiation between what we consider formal justice systems and what is informal. Formal justice systems simply refer to the systems that are set up in the law and which are therefore enforced through the mechanisms and institutions established by law, such as through the judiciary. So for instance, you'll be talking about going through the formal justice system, meaning that a person will engage with law enforcement, and then they will appear before a court, and then they will go through a judicial process. They will end up either in corrections or any other rehabilitation kind of services, or probation, and that kind of, so that process is formal in that manner. However, outside of those institutions, there are many other processes that still deliver justice, that in the simplest manner, you would say systems that assist in dispute resolution, in conflict resolution. And those systems can exist outside of the judicial system. It can exist outside of law enforcement and the institutions that we currently perceive as being part of the formal justice system. So when we speak in an African context, for instance, we know that our societies are founded on processes of justice that are emphatic on restorative systems, traditional justice that can vary from having elders resolve issues to having community-based dispute resolution mechanisms. It can also include religious forums, which are very critical in some countries in the African continent that have a very high religious inclination. And so most or a lot of disputes are solved within that process. But there's also administrative processes. And administrative processes, quite frankly, in some of our societies are some of the more used, where we have the chief resolving disputes at the local level, but also think about, in relation to children, dispute resolution within the education system. And those are also administrative processes, which we also need to pay attention to. So when you talk about the divide between formal justice system vis-a-vis the informal justice system, we actually have a larger proportion of access to justice happening in the informal justice mechanisms in the way we conceptualize the two. Yeah.
Thank you, Katha. So I'm thinking about children here and informal and formal kind of justice system. So if I spank my child at home because they have done something interesting, is that's informal, right? But is that access to justice? As you go that, I want Juliet to come in and just describe the child-friendly justice, because we're talking about justice, but there's that what we call the one for children. So like for me, I'm thinking when I spank my child because they have done something wrong, probably that is justice, and I know it's corporal punishment is illegal, but for some parents, they're thinking I'm doing justice by instilling law and order in their system, kind of thing. So, Katha.
Okay, you kind of put me on the spot on this because that is not how we would think about justice. Definitely there is levels of what the individual level of conceptualization of justice is different for each of us, because there is that sense of fairness, what is fair, what is not fair. There is all that. However, most of the time when we are talking about children engaging with the justice system, we are talking about children engaging with the system because either they've been violated and they want to speak to somebody outside of themselves or outside of their immediate environment, which would mean outside of their family. You would also be saying that probably a child has done something that to people, maybe most often outside of their family environment, is a violation of certain of their protections and rights and entitlements, and therefore that they want that child to be either disciplined or to be punished or to be rehabilitated in some way. Or thirdly, you're saying that this child has been a witness of something that happened and the justice system is interested in hearing what that child has to do. So most of the time, we are not really mostly talking about what is happening between the parent and the child in the form of access to justice, but how can the child access a system or the system of justice, the mechanisms of justice that will be beyond the home. However, if the violation is happening in the child's private space, like, there's a violation happening in the child's space at home, that means access to justice means that that child should be able to access that external mechanism to arbitrate between them and the person in their private space who is violating them. So if a child is experiencing domestic violence from their parent, whether it is in the form of corporal punishment or other higher form of violation, the child, we are saying that in that country or in the context the child lives in, there should be a way that that child can talk to someone else to arbitrate the dispute between them and the parent, or to protect them from the parent, or for them to be able to say that I don't like what is happening to me. In the simplest terms, that is just how it is, that the child should be able to have another avenue to raise what is happening to them and to hear that they've been heard and something has been done about it.
Juliet, is she there?
Yes.
Or she?
I'm here.
Sorry. So I know you're very passionate about child-friendly justice, but because you already know what is justice, what is a child-friendly justice?
So, you know, I like the discussion that was going on about what is justice, because I was in another forum where someone said, if a child is, say, a victim of abuse, for me as a lawyer, I would like to see the perpetrator arrested, convicted, you know, put away. But what is justice for the child? But I'll leave that to the professors who are talking to us about justice to think about that. However, what is child-friendly justice? It is a system. And the one thing that is very, very important for us to get out of this discussion is that it is a system that is essentially focused on children. It has two particular strands, and I've read widely on various professors what they've said about it. But essentially, it must focus on the child as a person who is a rights bearer. So a lot of times when we think about child justice, we are thinking of a child who's in the system who probably needs, for instance, protection so that the child is safe within the system, so that the police, for instance, does not harass this child. But what about the child who is in the system who needs to be educated, to be fed, to be heard? So a child justice system must first of all focus on the child as a whole, as a child rights bearer, as a bearer, not as a recipient of something, but as a bearer, a child who can actually make demand from the law, you know. The other thing is that, of course, it must focus on now protection of the child while they are in the system, and it also has to focus on prevention. So how do we ensure, and I like what Teresa also started, the discussion that she started, we must try as much as we can as professors, as lawyers, as adjudicators, as teachers, as parents, to ensure that the child does not get into the system in the first place. And that is what, if you look at the UNCRC, if you look at the African Charter on Rights and the Welfare of the Child, their spirit behind them, first of all, is really to make sure that the child is not coming into contact with the system. And that is what a child-friendly system must first focus on. How do we ensure that that child never comes into the system in the first place? And secondly, if the child has to access the system, how is that child protected within the system? And thirdly, while the child is going through that system, how do we ensure that the child is receiving healing at the same time? Because we can agree that the justice system is not the most friendly systems of this world. And I'm part of it. You know, I'm probably part of the problem or the solution. Right? And so a child-friendly system, I want to say just overall, is that one that focuses on the child rights and is fully focused and sees the child as a child rights bearer. Secondly, a system that focuses on prevention. How do we make sure the child never comes into the system in the first place? And thirdly, a system that protects the child while they are going through the system. And lastly, a system that is focused on healing that child as they're going through the system. So when they come out, if they don't come out better, they come out the same way they probably went in. It's hard, it's difficult. It's also an ideal situation, which is where I live mostly concerning children. I want to live in this ideal world. And I'm hoping that as we are discussing that we're able to come out with that, with some of these solutions towards this ideal world for children.
Thank you so much, Juliet. Violet, Juliet has said what a child justice system, ideally, in her ideal world, which I think we live in the same planet with Juliet. So, but how does it, what does a child-friendly justice system look like for boys and girls? Violet? Violet?
Hello?
Yeah, go ahead, Violet. So you had the question?
Yes.
Okay. And
yeah, so
your camera.
Yeah, I think I heard the last part.
Okay. So
yeah,
so
you're saying what?
Go ahead, Juliet. Violet.
Yes, you're saying what does a child-friendly justice system look for, like for boys and girls? Was that the question?
Yes. Yes, Violet.
Yes, so as the previous speakers have highlighted and enlightened us on what justice is and what child-friendly justice is. When we look at girls and boys, they do have different needs. So just as they have different needs in life, when they are accessing the justice system, their needs are also different. So for girls, this is a particularly vulnerable group of children for obvious reasons that we already know, that girls do face multiple vulnerabilities because of their age, but also their gender. And this brings about intersecting challenges, and then which leads to marginalization and discrimination, as well as exploitation and deprivation.
Violet? I think we've lost Violet, but she had mentioned she's having challenges with her internet. So I'm going to ask the same question. I'm trying to see who is here. So I'm going to ask that same question to Winfred. Winfred, so because Violet is unable to answer that question, how does justice look for boys and girls?
Well, I will speak within the context of Uganda. And as Violet had mentioned, the justice system between boys and girls is different, based on gender first and foremost. And then you also look at the nature of offenses the children actually commit. I will restrict myself mainly to children in conflict with the law, because I'm sure one of us will discuss children in contact with the law as we see them as victims. You tend to find that when they get into the formal justice system, they are all treated the same way. Whatever right a boy has, the girl will have. So ultimately, at the end of the day, a judge or a magistrate will tend to sympathize more with the girl as opposed to the boys. Reason being, when they're adjudicating these cases, they take into context the social, economic, and cultural background of this child. So when we talk about justice in that sense, vis-a-vis boys and girls, girls tend to be looked upon more with sympathy as opposed to the boys. And you find that most of the girls that end up getting into the formal justice system are a victim usually of circumstances. The only time or the cases where you find that the judges and the magistrate tend to be neutral is cases of child-to-child sex. And those we have quite a bit. So that is the perspective I could share with you from Uganda.
Thank you so much, Winfred. So Juliet, I'll come back to you again. Winfred has mentioned a case of children in contact with the law, children in conflict with the law, and probably not all of us are lawyers. So how do children access justice? Because we're talking about access, and the theme for the Day of the African Child this year is access to child-friendly justice. So how do they access?
Thank you for your question, Jennifer. I want to share with you an experience I had. I have worked as a victim advocate, child victim advocate. One of the cases I had experience of being part of is a very sad case where a young girl was rescued from the streets. Actually, she wasn't rescued from the streets. A young girl who was in school but used to beg was raped, defiled, actually. And by the time the case was coming to us, she was in hospital. The girl eventually went to court, and the organization I worked for then took this matter to court, and I was the victim advocate. And that was the time before the Victim Protection Act in Kenya. So therefore, we didn't, as advocates, we really just had the opportunity to guide the prosecution on the question that they would ask. So we really didn't have a voice in court. And this young girl, she eventually broke in court. The whole time when I spoke to her, this girl, when she told this story, she told it in the most removed way. It's like it didn't happen to her. It's like she watched someone, do this gory act to her. And eventually, when we went to court, when the magistrate sat next to her, now our courts in Kenya, you know how they are. For those of you who haven't, they're not child friendly, especially not this particular court. But the magistrate sat next to this child and asked her to explain in the simplest of ways what really happened. And the magistrate shielded this child. So I'm trying to show you, if you can see me, how she shielded this child from seeing or looking at the perpetrator's eyes. And that is the point. This child cried. She cried so much. And she explained in such painful detail what happened. Needless to say, the case went on. And she was able to testify very well. I mean, there was so much evidence against the perpetrator. And as the matter went on, it took actually quite a while. Unfortunately, I wasn't there long enough to actually see the case to come to an end. And what was really unfortunate for me was not the fact that it's not what really happened to this child. The worst part is that like a year or two later, or 1.5 years later, I met with someone who knew this child and asked me, how can you allow this child to go back to the streets where she got defiled? So if I was looking at it from a point of view of maybe, I don't know, a prosecutor, I would have said I went to court. I brought evidence. And as a police officer, I have done my investigation. And as a magistrate, I have found this person guilty of the offense and I've convicted them. But for this little girl, she's back on the streets where she was first defiled. The fact that this child, I mean, this is like the second abuse that is happening to her, because this child ought to be in school, not begging, having access to food, having access to shelter, but instead she's actually on the streets, even after whatever happened to her happened. So the system kind of dropped her. And the question I want to ask us, as I answer this question about, how do children access justice, is this really justice? Do we think that what this child got is actually justice? Yes, the perpetrator was, put away for life for gang defilement. But the other person could not be found, unfortunately. But did we really give this girl the justice that she deserved if she is still in the same precarious and vulnerable position that we found her as advocates? So how do children, for it to be justice, it must first of all be accessible. And that is what justice is all about. That if it is not accessible, and if I cannot be able to access redress systems and mechanisms, then it is not a just system in the first place. And so therefore, we have children who come into and I think Katha had also talked about this. Children come into the system, whether if their parents are actually at loggerheads and they do not agree on what to do about them and concerning them. So at that point, the children will actually come into the system because they come into so that the system can decide who do they go with, who do they go to. Secondly, the children also come into the system because sometimes they are lost. They are out there in the streets. They are delinquents sometimes, and the children have to come into the system. We have normalized this so much that I hear parents say, I will take you to the police when your child is indisciplined. We have normalized the system too much. And I think it's a time that we step back as a community and say, maybe this is not the place to put our children. So, and those children, we call them children in need of care and protection, because essentially what these children need is not to be corrected. They're lost either in their senses, because, that's where they're delinquent, or they're unaccompanied. They're unaccompanied minors. There's a group of children that we particularly forget sometimes when we talk about justice. And these are children who are on the move. Children who are either refugees, children who are victims of trafficking, children who are IDPs as well. And sometimes we forget that these children are actually also children who are in contact with the law. And then we obviously have now the children who are obviously in conflict with the law. So these are children who have actually done something wrong. And what happens to these children is that they are brought into the system either by their parents or guardians, or the system picks them up. And so they find themselves within the justice system. And for all these children, the bottom line is that they must be able to access child-friendly justice, not justice, but a system that will treat them like the vulnerable people that they are, a system that speaks their language, a system that is helpful to them and to the needs that they have at that particular point. I cannot insist enough on looking at the child as a child rights bearer, as a bearer of the rights, and not so much just as a recipient. Thank you.
Thank you so much, Juliet. So I want Yvonne to come out here, because all you guys are talking about going to the system, like, so Yvonne, I want you to talk about the alternative dispute resolution. So how to avoid a child from going to this to the system, and ensuring that the dignity of the child and the innocence, for me it's more of the innocence of the child is safeguarded. How can we do that?
Thanks a lot, Jenny. Maybe I could just start from mentioning that within the international and regional instruments related to children, access to justice has already been defined quite clearly in various articles of the African Charter on the Rights and Welfare of the Child, and particularly Article 4. That talks about the best interest of the child, and Article 17 that really delves really in detail on access to child justice, as well as Article 18, 19, 23, and 25 of the African Charter. The UN Convention on the Rights of the Child also really focuses on the importance of creating a conducive child-friendly justice system in Article 14 of the UNCRC. So when we talk about alternative dispute resolution, this is more or less, particularly when we are dealing with children in the conflict, children in conflict with the law, where we want to ensure that detention is used as a last measure of resort. And when we talk about alternative dispute resolution, this is when we are trying to divert young people who have been in contact with the law or who have undertaken some criminal acts to not be bogged down into the system. So there are currently a number of alternative dispute resolution mechanisms, such as family mediation, where we want to ensure that families are provided with the necessary support to ensure that they address these delinquencies or delinquent issues that happen at home. There's also the diversion policies that a lot of countries have put in place to ensure that diversion from the normal or formal justice system for children is taken into account. When we talk about diversion, this is where we also want to ensure that children are then provided alternatives to delinquent behavior, where they can still be able to access education, where they can also be able to get into skills development to provide them the support to deviate from delinquent behavior. I think this is where also the community-based alternative dispute resolution really take into account, particularly for minor offenses, where alternative dispute resolutions would also focus on the use of the alternative community-based courts, where we want to ensure that children are not really taken into the formal system, but communities can gather around and provide a conducive and safe environment for minor issues that children are involved in can also be addressed. So when we talk about offenses and the alternative dispute resolution, it's very important also to ensure that we understand that sometimes alternative dispute resolutions, although they are in place, the formal justice that Nkatha, Winifred, and Edmund were referring to, still become very important when we are working with children. And we find that the UNCRC and the African Committee of Experts has really mentioned, particularly in General Comment number 10 of 2009, where the UNCRC, the UN committee, encourages states parties to set a minimum age of criminal responsibility. And this should not be too low in view of the fact that alternative dispute resolution mechanisms should take place without having children come into the formal justice system. So in Africa, Jenny, we are seeing that countries have really ratified and are following some guidance that have been set by the UN committee and also by the Human Rights Council around guidelines for access to justice and administration of justice. But what is of concern is that out of our 54 African countries, 15 African countries still have a minimum age of criminal responsibility that is really way too low. We have countries in Africa that have a minimum age as low as 7 years. So you could imagine, colleagues, if we are saying that a 7-year-old can be held criminally liable in a formal court, then this is where it becomes very important for us to be able to really encourage our state parties to consider raising their minimum ages of criminal responsibility, but also counting on the alternative dispute resolution to ensure that children do not reoffend or are not actually viewed as offenders as young as 7. So I'll stop here, Jenny, if there are any other additional reflections.
I can see quite a number of hands, so I will. I know we had said we are going to finish up and then Q&A, but I think I'm going so that we do, because the next part of this panel is more about policy work and what needs to be done. I think for this first part, I'm going to take the first. Wow, I said first 3 questions. I already saw the first 3 questions. So the first question is from Rosaline, and then I'm going to take Marian. And then I'm going to take, I think, Wamboi Kwagung. Sorry, if I spell your name wrongly, you'll forgive me. Please don't take me to court. Rosaline, you have a question?
Yes, Yvonne, thank you so much for your contribution. And my interest was in the community-based courts that you talked about. In Kenya, we have kangaroo courts and people are very concerned about them. In as much as we want to encourage people to solve children issues in the community because we do not want children to come into the justice system, one of the fears that many Kenyans have is that kangaroo courts will not be monitored in the matters that they will be handling. So how do you, in your country, make sure that you monitor the community-based courts and what matters do they solve and who is involved in these community-based courts?
Thank you. Marianne?
Hello.
Yes,
so
go ahead.
I have 2 questions. My first one will be, how do we distinguish between justice as it appears for boys and then justice as it appears for girls, especially when the 2 children are both offenders of the law in the same offense? How do we distinguish between the 2, justice for boys or as it appears for boys and then justice as it appears for the girls? And my second question will be, since we are speaking about justice or child-friendly justice, so far we've spoken about it generally in the criminal sense. Is it possible, especially for us as lawyers, that we can have justice for children and not gear towards the criminal side? So where it is the child who is demanding such protection or rights from the law, is it possible that, especially in countries like mine where we can't do private prosecution, is it possible as lawyers that we can have justice in civil cases? So even if the offense was criminal, is it possible for us to have justice for the child by towing towards the civil law?
Okay. I think one question goes to Edmund, and I think the next one goes to Nkatha. And then let me take the questions and then we can all respond to them. Kirindi, Kirindi, are you able to ask a question? And then Reverend Taylor, you're next. Kirindi? Okay, I don't know why it's not talking. Kirindi?
Hello, can you hear me?
Yeah, go ahead.
Okay, thank you. And greetings to Edmund Foley. This is a co-facilitator, the Kofi Annan. So, and the question goes to you, my brother. We've had the lectures, and we see a lot of what the human rights situation is in the different countries.
Right.
But how much of the human rights principles are truncated and titrated down to the child? Because I think a child, as a rights bearer, has a right to certain levels of information that protects them and informs them of what the system is, so that that access is something that is a knowledge-based thing for them. And so my question is, what are we doing in Africa to ensure that it is not a top-down arrangement, as all our parenting and our traditional systems and all the spaces, because we talk about giving people the power to what extent that they have it, but we don't actually do it. It is done still by the same adults who block and create a lot of boundaries. So this question goes to you, Edmund.
Thank you, Kirindi. Habari.
Nzuri sana, asante.
Yes.
Edmund, just the last question, and then you can cover all of them. Reverend Taylor, go ahead.
Thank you, Jenny. I've been listening through and through, and it may not be a question, but a comment to say that for justice to happen, it requires certain infrastructure to be in place to ensure that children access this justice throughout, including rehabilitation itself. And the question is, we have not seen many states that are that are investing in children to the extent of ensuring that there is adequate infrastructure to support the child, so that they minimize the child getting to the criminal justice system. So it's more or less a comment. Thank you.
Thank you, Reverend Taylor. Edmund, Nkatha, and Yvonne, over to you.
Thank you very much, Jenny. I lost connection a second, but I thought I heard you say a question for Edmund. I heard Kirindi, so could you kindly remind me quickly if there was anything that I had missed?
Okay. What's the question was from Mala. I can't remember it. I didn't write it down. But Nkatha, did you get the questions? Nkatha?
Yes, sorry. I have two questions in relation to informal justice systems.
Yes, it was more informal.
Yeah. I will respond to that maybe after Edmund. And then there is also a question of, I think it's just trying to make a link between what the legal provisions are vis-a-vis what's the reality of children's access to justice. I mean, not in that manner, not in the exact words, but I'll try and respond in relation to where the legal systems basically can become a hindrance to the effective access to justice for children. If I'm not wrong, I think those were the two main issues. I think I can come back to them, but if Edmund can go, because I think to answer the second question, there's something else I would want to raise.
All right. Thank you very much. Quickly, on the interface between the systems, I think one hurdle, but also an opportunity which children face, is the fact that generally with the formal legal systems that we have in Africa, and when my colleagues were explaining the formal and the informal, we must also appreciate that a lot of our formal systems, what we call formal, were borrowed. So it's either the French civil law system, the Roman Dutch law system, or the common law system, which we inherited at colonialism. So from those perspectives, you find that for a child to even access a court or even any other mechanism that would help that child resolve an issue or get protection, they need an adult. the child technically cannot proceed on his or her own. And that presents both a hurdle, because if you don't have enough quote unquote adults to take up the interest of children, then your street children, your other vulnerable children are lost in this whole enterprise until you get civil society organizations or other interested adults to take up the cause of these children. But yes, that same hurdle then presents us with an opportunity to do better. And that is why, under the guidance of the African Committee and the CRC, we've seen a lot of documents and guidance to states to see how they can put into their national legal frameworks these systems that would make children access justice better. And so I've been part of policy-related work across the continent together with colleagues like Nkatha. We've assisted various countries, even as they draft laws, but to also look at those systems that are close to us in Africa. Yvonne has talked about alternative dispute resolution mechanisms. It's not only that, but we also have systems for protection for children who are in need of alternative family arrangements, where you can have, community support systems for such children. And so indeed, yes, I think the time is opportune for us to keep on the work of marrying the two systems that we have, the formal and the informal, for the benefit of children, but then also encouraging more of us to work in that space. And Kirindi, to dovetail into the points we are raising, yes, we must admit that at some point we have siloed the human rights thematic work into children's rights and other human rights. But definitely, the principles that govern human rights in terms of indivisibility and inalienability and interdependence and all of that are very, very present in the child rights space. I would say even more present than we see with the other human rights regimes. So the work for education and awareness raising on our part should continue. For me as a lecturer now and as a trainer, you're opening my eyes to the fact that I need to stop that siloed education where I organize human rights training workshops, talk about human rights generally 80% of the time and give 20% to children. I agree we must sort of separate and highlight children for their particular needs. But in so doing, I and all those in this space must not do it in such a way that it seems to put children sort of at the back of the discussion, but rather integrate them into the discussion. So I'll pause here and let the others take it up.
Okay, Edmund, if I may just pick it up in relation to the two questions that were asked. I think I would first deal with the question relating to use of informal justice mechanisms and the fact that it is actually true that most of the systems that we have, particularly in rural areas where disputes get resolved outside of court, there have been numerous reports that children's interests are not protected. What the reality is, and it's unfortunate that Violet was disconnected here, but in a previous project that I was involved in with the African Child Policy Forum, doing a study, a Pan-African study on access to justice, one of the key findings that we found is that, in fact, more than 90% of children do in fact access justice through these mechanisms. So it's not a question of whether we want them to or whether we are promoting it. The question is, the issue is they are there. What do we do to make sure that those mechanisms are not violating their rights? So other than alienating the informal justice system in favor of investing all the resources and time that we have in the formal justice system, which we still are doing, I think there is a question to be asked about us and about context and about relevance for us as child rights advocates of what does it say about us if we spend all our energy focusing on the 10% and abandon 90% because we don't approve of it. I think there are lessons, just looking at it from my research, I find that the informal justice mechanisms do actually have a lot of lessons for the formal justice mechanism to learn and to pick up. One, for instance, children never get incarcerated. We've been trying to sing about that for the formal justice mechanism. It doesn't happen. But the informal justice mechanisms, children don't get incarcerated. Children go through the process with their parents, so there is always oversight. So even though we are saying that there are certain protections that may not be there, it's true. Those systems are very quick. Justice is very quick, you know. When it happens, the children go before the issue is decided and it goes away. Those systems have the support of communities, and when the decision is made, the decision is actually also restorative. So for the children, it doesn't have lifelong consequences. It has, you know, the immediacy of resolving and moving on. I can go on and on about the benefits of informal justice mechanisms. The one thing that they don't have is that they are not standardized. Why are they not standardized? It's because I feel, in my view, that on the African continent, we've sort of ignored the reality of the fact that informal justice mechanisms are here, and we have to deal with them, and we have embraced the formal mechanisms, which is fine and good. But I don't think that we should be abandoning one for the other. I think they can coexist. And it is only by acknowledging and accepting them that we can then start to regulate them. Because if you don't regulate them, they will not disappear. They will just continue perpetuating the wrong things. So I just think that this is one of the major conversations that I wish that in the human rights sector, in the children's rights sector, we have a meaningful conversation around informal justice mechanisms, not from a demonizing them perspective, but from our what can we learn, what can we do, how can we improve them perspective. I think there's plenty that we can benefit from. So that is one of the things that I would think that is important. The second thing is that, in fact, the divide between formal and informal mechanisms also exposes another issue, which is that most of the justice systems that we have work for a model child. They work for a child who will access, you know, legal support. They work for a child who has parental oversight, and therefore, you know, you can release them. You cannot incarcerate them because, you know, they have a residence, they have an address, you know, where they will be, you know, who is going to be having oversight of them. So if you have probation workers working with them, social workers working with them, they know where to find them. Unfortunately, this reality only applies to a very small number of children who interact with the justice system in that manner. In fact, children who will be in the justice system as children in need of care and protection often at times are not that child. And most of the time, also, the children who are in conflict with the law are not that child. One of the difficulties of, you know, trying to reform the justice system is the assumption that we have in mind, which is, it's common, it's normal, that we think that all children are children who live in a family and who have some kind of parental oversight. That's not the case. Majority of the children who interact with the system are actually children who are out of that norm. So we need to think about the child who is the outlier in our society and try to make the justice system accommodate those children, not to make the children, you know, fit into the justice system. We have to prioritize the child and then subject the system to accommodation of all these needs. So basically, we need to flip the model where we're trying to fit children into the system and make the system fit the diversity of needs and representations of children across our communities. So I think that is really something that, as we think through this time, this year of access to justice, let's look at, let's not stop. I think we need to stop, you know, putting the justice system, particularly the formal justice system, on a pedestal, and then saying that all children need to conform to it. We need to test the system against the children, as the other way around. That is my view. Then the final thing I would want to speak to, I think the question related to how do we then ensure that, you know, I really didn't get it in the entirety, and I hope it can be repeated if I don't get it correctly. But I think it is a question related to the idea of justice for children, particularly when, you know, as lawyers, we have very particular ideas of how children should access justice. And I think Juliet raised that through the example that she raised. I think for me personally, as a child rights advocate, one of the depressing things I find is that I feel that this year we are talking about 30 years of the African Charter on the Rights and Welfare of the Child. 30 years. This conversation might as well have been happening in 1990. You know, I mean, there's a lot of talking and there is very little changing. And that is because we exist in parallel spaces. Lawyers exist on parallel spaces with the social workers. They exist on parallel spaces with government policymakers. And so we all sit in parallel spaces. I sit in academia. You can write articles from here to the end. Those recommendations don't end up on any desk of the people who actually implement these things. There isn't an integrated conversation, particularly in the African region. And we are too easily wedded to the theory and knowledge and models that come from Western countries, that most of the time, our context demands that we localize them. And we are not actually localizing them. What we are trying is implementing them. So I think, in my view, I think as we reflect also on the 30 years of the African Charter and the Rights and the Welfare of the Child, on this occasion of the DAC, I really feel strongly that one of the things that we need to, as we take stock of the progress, I am so glad that we are talking about the what as opposed to the ifs, because 30 years ago we were talking about the ifs. We were not even sure that these are entitlements. At least we've gotten to the point where we're talking about the what of access to justice. But I just hope that we don't make camp here. Like, we don't stay here, eternally talking about what needs to happen, and we are not actually doing it. To do that, we need to we need to have a local conversation. So we need to localize these discussions very, very much to our realities at national level. Yeah.
Sorry,
Thank you.
sorry.
Sorry. Okay, guys. So I'm going to give each one of you a 30 seconds each, so that you can be able to. And I love what Nkatha has said. The system should be tested against the child, not the child against the system. I love that. So 30 seconds, and then Yvonne come and respond to your question, to another question before we move on. We need to move on. We have 3 more topics to go. Elvis, go ahead. 30 seconds.
Yeah, should I start counting now? Maybe. Just to beef up on what Nkatha just said, because at times our conversation gets so boring, because when you read articles that were written 15 years ago, and today we are still rehashing the same conversations. This year, the continent is silencing the guns. It was the same thing in 2014, but now the guns are louder than ever. And it's the same conversation that we have about children's rights as well. For me, if we want to dare the system, is that we take this back into our various homes. And this is where we have to start creating the balance between the issue of parent-child relationship and how adults are involved in enabling our children to access justice, be it at home or when they go into the formal system or the informal system, which happens in our communities. We also have the issue of religion and all whatnot that have completely, limited the access of children to access justice. One other thing that we have not dealt with, I think, comprehensively in the continent, if we are going forward, is that we have to start looking at the issue of age balance. At what age should we allow, or at what age should a child access justice? For me, if we create a balance with age, then we now have a system where it might reflect the South African system, for example, or maybe what Uganda is doing, or Malawi is doing as well, where we know at a particular age, it is compulsory for that child to access justice, unless the child proves incompetent, to understand the issues that are discussed at that particular time. Then we can now look for other means of involving adults into the system. But the parent-child relationship is something that we need to discuss going forward, and we need to see how we can use that platform to enable our children to have access to a better justice system in the continent. Thank you.
Thank you, Elvis. Quick, Yvonne?
Thank you, Jennifer. Yes, thank you. I think I definitely like what Nkatha and Edmund said about not putting the informal system on a lower grade than the formal system, as we've been saying. But I think for me, what I would like to say to Rosalind is really a multidisciplinary approach to access to justice for children should not only be focused in formal systems, but it can also work in informal systems, where you were talking about potential abuses within the alternative dispute resolution. So there is possibility of training chiefs, of training local or community-based child protection actors or child welfare committees. These are now a very common parlance in most African countries, and investing in their ability to use that child-sensitive approach to community-based child protection systems will be very important as development actors. I think once local chiefs, local judges, these community-based child protection actors appreciate the need to protect a child within these informal processes, we will not be actually recording what you are terming as kangaroo courts, because there is that capacity to understand the importance of protecting children in these processes. And I agree with Nkatha, these are the fastest way children access justice, or even the most vulnerable. So it's very important for us to invest in this multidisciplinary approach to ensure that chiefs, informal actors that are working at the community level understand that child sensitivity when we are dealing with these alternative dispute resolution mechanisms. Thanks.
Thank you so much, Yvonne. So we have, I want to acknowledge two important people who have just joined us. Honorable Justice Martha Koome, a judge of the High Court in Kenya. And I've also been alerted, Justice, I'm hoping, Edmund, I'm going to pronounce this correctly. I don't offend the judge from Bangladesh also. Welcome. Thank you so much for joining us. This is a very important conversation, and we would also want to hear your perspective from the other side of the bench. You know, we are talking from this other bench, this side, but we'd want to hear from the ones who actually implement these things we are talking about. So quickly, I want us to talk about the policies. You know, I've had there's difference in policies, different in policies. But what is the outlook? What is the global outlook of what does these policies look like? So where's Nkatha? So Nkatha, shortly, like 1 minute, just give us an overview. Give us an overview of how the policies look like.
Okay, sorry. So we have sort of two levels that we can think about if we're talking about at an international and national level. And these two levels really is what we have at a UN level and what we have at a Pan-African level. And then obviously there are certain other levels that we can go further, which is sub-regional, because apparently there's growing sub-regional mechanisms and sub-regional interest in children's matters. When we talk about international, really, we are talking about the standards that have been established at the UN level through the UN Convention on the Rights of the Child. And I think some of them were already referenced by previous speakers, because the CRC is the largest instrument globally in relation to children's issues. And the CRC sets out the minimums and the approaches to children's right to access justice, which is in Article 40. There is an entire general comment which Yvonne spoke to quite extensively in terms of, you know, calling upon states to have to set minimum ages that are not very low, so that we don't punish children at a very young age for committing of crimes, but also just other protections, such as things as simple as, you know, deprivation of liberty for a child should always be a measure of last resort, that we should have a system that is dedicated to protection of children. That is really, you know, like just a highlight of some of the standards that are set up at the global level that I may not be in a position to get into. But I think on an African continent, and considering that we are speaking in the context of the Day of the African Child, and the Day of the African Child as informed by African Union mechanisms, I think it is better for us to draw those standards from the African Charter on the Rights of the Child. And the Charter, basically, one of the main things that the Charter does is that, unlike in other instruments, is that it's very clear that on the African continent, we are deliberate about defining children as people below the age of 18. So irrespective of how your local or your national law describes children, that all these protections we are talking about run up to the age of 18. Of course, the African Children's Charter doesn't go very far away from what the CRC says in terms of access to justice. It still calls for the same protections and the same requirement for minimum ages, it still calls on African states to be careful about incarceration of children, deprivation of liberty as a measure of last resort. It still talks about recognizing the need for legal aid, for instance, on the African continent in access to justice. But these things, how do they translate to national law? I think is where the rubber meets the road, because these instruments are out there. We have more than 49 African countries that have ratified these instruments, and they are committed to the standard. However, when we look at national level, the policies that we are talking about, Jenny, is that the approaches at national level have been very different. So some countries have a Children's Act, and then the Children's Act has a section on access to justice. And then within that section, we speak a little bit about, children accessing justice should, they should maybe have legal aid. In some countries, there is reference to legal aid. Some countries, there is no reference to legal aid at all. Some countries talk about children having separate courts. Others don't talk about that at all. So there is a disparity. There is a variety of approaches that African countries adopt at national level. The challenge with that is that we are not in a position to speak in a collective voice about whether or not we are making progress to achieving what the African Children's Charter requires, or whether we are in the process of achieving what the UN CRC requires. So, for instance, some of our African countries have made a lot of progress. We have separate court systems, and I think one of the good practices that I would want to point out is that in a number of countries, they're having a system of establishment of one-stop centers models for access to justice, where we are able to have children come to these one-stop centers. They get the services, they get judicial services, they get law enforcement services, they get social work support, and they get medical services where that is necessary. For instance, in the cases of sexual abuse. Those models are mushrooming in different countries, but are not, we don't share enough of that information with everybody so that we can, we don't waste more time trying to invent new ones. I think in Tanzania, in Zanzibar specifically, there is a Mkono kwa Mkono centers. I think that is one very interesting model, for instance, of such a one-stop center that have been piloted in African countries and which can be reproduced. So to close, I think maybe one of the main things that we are not doing on the African continent is that we are not cross-learning enough. We are not sharing our experiences and successful models enough so that, it can work from country to country and reduce the marginalization of children in access to justice.
Thank you so much, Nkatha. I've been told that Dr. Anne Skelton is here, and she's written widely about policies in Africa. I don't know, for a minute, and are you able to speak for just a minute and just give us an overview? I know it's a bit, it's a thing. Are you there? Are you still there, Anne? Is she still there? I think she is not here. She left. So, Winfred, you've heard what Nkatha has spoken about the different policies, and you're in Uganda, and you're Ugandan and Kenya, East Africa. So, what do we say? Because the other day I had a very interesting story about the way Kenyans run out to Uganda or Tanzania because they're running away. They go cut their guts and come back to Kenya because they will not be prosecuted in those countries. What are these legal frameworks or policies? Are they harmonized, or what can we do to ensure that access to justice is equal across regions? Winfred?
Thank you very much, Jenny. For starters, Uganda has made significant steps in domesticating both the international and the regional instruments. As Nkatha put it, we do have rights that have been spelled out, especially for children, regardless of whether it's a criminal matter, administrative matter, or civil matter. They all have a right to legal aid. However, the challenge with most of these laws is the implementation. That is where the gap is. We are talking about all these fantastic laws, but we are failing miserably on implementation. How then are we able to speak to the requirements of the law if we ourselves are falling short of actually ensuring that the steps that we've put in place in our laws are actually being followed? I believe it was Elvis that talked about age. One of the biggest challenges we're having right now is birth registration. And when a child ends up in the formal justice system, that is one of the biggest problems we're facing. You'll find children ending up in adult facilities. Why? Because the parent does not have a birth certificate. The processes a parent has to go through to get a birth certificate right now is very, very complex. And those are some of the issues I believe UNICEF and the government of Uganda are trying to iron out. How easily can they take birth registration services closer to the people? The other issue is to do with mindset, perception. How are we able to say and discuss access to justice for children without allaying the public fears? You know, the challenge usually is once the child gets into the system, the default position of the community is, oh, that is a bad child. Whereas we don't take a step back to say, okay, how do we change the perception of the community so that such that the informal justice processes will deal adequately with some of the cases that come up? I believe one of the participants raised an issue of how do we distinguish cases between boys and girls. This is one of those cases where you can actually refer a case, especially to do with child-to-child sex. We call it simple defilement between a boy and a girl between the ages of 13 to 18. So basically 14 to 17-year-olds. You'll find that a girl's parent will run to police and accuse the boy of having sex with the daughter. But at the end of the day, the victims, both children are victims, both children are witnesses. So how then are we able to come up with a lasting solution? And until we start talking and walking the talk and saying, okay, we have these laws, we have these policies in place, how do we implement? We are all wasting time. And most importantly, when we are discussing these issues, where is the child? Do we speak to these children? Do we seek these children's views? I think that is what is missing in all this conversation. It would have been nice to actually have a child, you know, sitting on the panel to try and get an understanding and a feel from their perspective. What would we do to make justice more child-friendly for them? I mean, in Kenya, between Kenya and Uganda, the laws are good. We are falling short on implementation. Thank you very much.
Thank you. So we have children actually in the attendees. So we have like a couple of children who are attendees, but we wanted this conversation among experts so that we can bring the children later to ask you guys questions.
Yeah.
So on her question, okay, I'm going to allow Violet to answer this question, and then we can move on to the next question. Violet, are you back? Violet.
Hi, Jenny.
Hi, sorry about the internet.
Sorry, our network is on and off. So
okay.
Yeah, I've been in on some conversations and off on others. Yeah, but I'm here now.
So I know you had prepared one for the girls, but just because now I can see you can quickly talk about harmonization of laws in Africa.
Yes, Jenny. So the issue of laws remains critical for Africa with regard to children in general, even 30 years after the adoption of the African Charter on the Rights and Welfare of the Child, as well as the CRC. Of course, much progress has been made in countries in that we have a majority of countries, over 30, close to 40 or so, who have specific statutes on children. And some of them, as Nkata said earlier on, that they do have specific statutes on child justice as well, just to make sure that they regulate more with regard to child justice. So in terms of harmonization, we see that they're very, when you start looking at the various provisions of the charter, that's when you find that there are many gaps in African countries. If we speak of the issue of minimum ages, so many are still lagging behind. And on that one, it's not just about minimum age of criminal responsibility, which speaks more to the criminal justice system. But if you also look at the issue of minimum age of marriage, you see that there are also discrepancies. And this is very important for access to justice for girls, because if you have minimum age of marriage that is lower for girls than it is for boys, for example, if you have 16 for girls and you have like 18 or above 18 for boys, it means that you are denying the girls that are in between like 17 and even 16 access to justice. Because if a 17-year-old is married, gets married, and I mean, they will not have recourse to justice because the law actually says that they can get married. So this is where we see that the dimensions for girls and boys are different in law. So in the issue of harmonization, yes, a lot of progress in enacting children's statutes in Africa. Some countries like South Africa have even a specific statute on justice, on child justice, and countries like Malawi have got combined statutes where they speak of child welfare protection as well as justice. So on that level, some commendable progress. But in terms of specific provisions, when you see how the extent to which they have been aligned with the CRC of the African Charter on the Rights and Welfare of the Child, that's where we have problems. And beyond that, when you also see how the needs of girls and boys have been provided for in these statutes, it's also different. So I know that this is more to do with harmonization, but when I got cut off earlier on, I wanted to say this point about girls and boys in the justice system, which I think is very important, and it also speaks to the issue of harmonization in that child-friendly justice should begin in law if it is to be, I mean, if it is to be friendly for both girls and boys, or for various groups of children. And we shouldn't only have blanket provisions for children, because the needs of these children are different. First of all, in terms of their gender, in terms of their age, but also their various statuses, the various groups of children that we have, like children with disabilities, children living on the street. So access to justice for a girl will be different in some respects to that of a boy. And access to justice for a child living on the street will be different to access to justice for a child living with parents. Access to justice for a child living in an alternative care institution will be different also from another child who is not in that system. So it's very important that the law is fair to all groups of children, because if the law discriminates or omits to provide for their specific needs, it makes it very difficult for that particular child to have recourse to the remedies that the law provides for, whether you're dealing with the civil system or the criminal justice system. So that's very important. And further on, to speak about girls, last year we did a study on girls and the law in Africa, where we saw that the three critical issues for girls are that there is rather four critical issues. There is like a lot of silence in the international and regional instruments on girls. The instruments that we have are silent on girls in most cases. They just provide for children. And when you look on the face of it, it looks like it's a fair system. It's a fair instrument for both boys and girls. But when you consider their different needs, then that's where it becomes problematic for girls to access justice using those instruments, just like boys would be able to. And then the issue of discriminatory laws, which we have already alluded to, and then the inadequacy of laws in the sense that you have penalties that are provided for example, for let's say the issue of defilement, which is quite a very common example in most of the laws. The issue of defilement of girls, the penalties are very low in some countries, that they do not have the deterrent effect that the law seeks to achieve. So in that sense, even if, perpetrators will keep on, defiling girls because they know that the penalties are not stringent enough to deter them from committing similar crimes or others from committing similar crimes. So inadequacy of laws, but also the issue that in the courts, there's a lot of patriarchal tendencies that we see. And this, I think, speaks more to the fact that most courts are manned by men. And with our plural justice systems and traditional justice systems where we recognize customary laws, and those customary laws which are not alive to the international and regional standards for children. In most cases, judicial officers will go to the bench with that in mind, with patriarchal tendencies in mind. So if a girl comes before them as a victim or a witness, the way they respond to what is being asked for, to the prayers being made for that victim the victim who is a girl, it's very different. You see the patriarchal tendencies, coming out quite often in most cases that involve girls. So the courts do have a role to play as well in making sure that we have decisions which respect the needs of both boys and girls in the justice system, whether you're dealing with a criminal case or a civil case. It should be fair to both boys and girls in Africa, because that's quite a big challenge. So for now, let me stop there and reflect on the other issues.
Much, Violet. I hope you're going to be able to stay with us up to the end. So Violet has mentioned some things like the way the law is not equal for both boys and girls. But when yesterday, during the launch on Tuesday, we were doing a children engagement, and a child asked a question which those of us who were in that meeting, we were all held aback. And the child asked, why when I lift up my hand, and I'm sorry to the judges in the panel, why when I lift up my hand, the judge tells me to put my hand. So Elvis, I know you are enthusiastic. You said you are possessed with child participation. How can we bring in child participation in children accessing justice? Elvis?
One of the challenges that we have, as I said before, is that we regard children more or less as people who are presumed incompetent. So when a child raises their hand in a court or to contribute to something about all of this, they are immediately presumed that do not understand the issue or that is being discussed, or that a child will not make meaningful contribution to that particular aspect. Whereas if we have been in situations where children have impressed most people in courts, where they've actually contributed a lot of substance that has helped judges to make decisions. And one of those areas is around dispute, marriage dispute, or divorces and all whatnot. In that aspect, in particular, children are mandated according to law to air their views because they are considered very important contributors and to assist judges to make that decision as well when the marriage is broken or it's fallen apart. The other thing is the issue of adoption, where we do not have a lot of children contributing in. If this issue gets to court, there is, in most countries in the continent, we don't have specific provisions that allow children to contribute in the case of adoption. And I'm thinking about a particular case in Uganda where a mother voluntarily gives up her children for adoption because she could not afford anymore to provide for them. But in this case, you might argue it in two ways, where you say, okay, the court did not want to allow the children to contribute in that particular case because what the mother was deciding and the facts that the mom gave to the court was actually in the best interest of the children, which allowed them to go to a better off family in the US. But I still think that if the children in that particular case, I've just lost the name of the case, but it's Salem something, it's a very long name. If children in that case were allowed to express an opinion in that particular case, they would have provided an alternative measure or probably to increase the number of visits or maybe to say, could we have some more time with our mom? But the issue of presumption of competence, children are generally presumed incompetent as compared to adults. So when they raise up their hands in courts and all of that, they are usually not accepted because of this barrier of presumption. And that's why I brought up the issue of age. And I said it's important that we have age so that at some point, the court should know that if a child at 12, for example, raises their hand in court, it should be mandated to listen to the child until the child is unable to make a substantive contribution in a particular case. So the age is something that we need to maybe discuss more about, or how we go forward about access to justice in the continent. And we do not have clear modalities on how we encourage access to justice in the continent yet. But we've had a lot of discussions around access to justice, and this is one of them that we're having. And probably we'll end without really knowing exactly where do we open the doors and say, look, we need to allow our children to make contribution on certain aspects when it comes to access to justice, either in the education. And I'll end by giving one example, the issue of reopening of schools post-COVID-19. You know, we are dealing with a situation where in South Africa, for example, where it is CSO and parents that have been fighting with the government and even went to court. And some of us observed the entire process. At no point was the child allowed to even raise an opinion. I watched on TV just once where two children were interviewed for 5 minutes, where they said they would like to go to school, but at that point it was already too late because their minds already had information from their parents and from civil society. The point here is when a particular child rights is violated, I mean, we're speaking about the child, we should allow the child to make an opinion, whether that opinion counts at that point or if it doesn't. In most cases, it does count because it helps the judges to make a fair decision. That is my opinion. Thanks.
Thank you so much. You know, so we need to talk about access to justice during COVID-19, you know, and what needs to be done during this time. And then we're going to go to best practices. I'm going to start with Yvonne. Yvonne, I know you had prepared something about access to justice during COVID-19. What needs to be done? And I can see people lifting up their hands already. Guys, let's finish up and then we can have time for question and answers. Yvonne, are you there or you are?
I'm here, Jenny.
Yeah, so you're speaking about access to justice during COVID-19. You've already spoken what is access, what is justice, what is child-friendly, but is it happening during COVID-19 right now?
Yeah, thanks a lot, Jenny. I'll just take off from where Elvis has left in terms of ensuring that, you know, we are creating conducive environment for children to also be part of these conversations around school access and how they can actually still also be able to continue with their education in light of the COVID-19. But when we are talking about COVID-19, foremost, we've heard from the opening remarks that it still is a public health concern, but the pandemic also has really affected access to justice, particularly on the unprecedented effect it has on justice system. So we find across Africa, courts are closing. There's really a reduction of adjusting of times in terms of operations of courts, and that also is coming at a very unfortunate incident where we are seeing increasing cases of gender-based violence, and also some very sad cases as well of child murder and also defilement of children. So it's really becoming a very glaring issue that access to justice is really negatively impacted, and the provision of timely and fair hearing for those that may be in conflict with the law, but also those that have been affected by perpetrators is really being affected. So in terms of what we are seeing, it's very encouraging to see that a number of ministries of justice and Judicial Services Commission, particularly the Zimbabwe Judicial Service Commission, Malawi has also come up with a justice sector strategy for COVID-19, where governments are really trying to see how best to actually have a mini strategy for response and recovery initiatives within the justice sector. So we have been seeing radio programs just really trying to conscientize communities and the fellow public on how they can access justice and what a court is in light of the COVID-19 outbreak. And the Zimbabwe Judicial Service Commission has been running these programs on national radio and ensuring that even the most marginalized can also get access to the information. Jenny, we're also seeing really some investments with some governments also on personal protective equipment for justice actors, really also following the WHO guidelines in terms of social distancing. But what was really key for me in terms of what I've analyzed was the prioritization of cases of gender-based violence and child development. And this has also come out in South Africa, where we saw a very unfortunate case in Durban where a woman murdered her child 2 weeks ago, and already the case has gone to trial. So we're actually seeing the justice courts really looking into access to justice at the most possible time through prioritization of cases. We've also been seeing remote functioning of justice courts. I think Zoom has become a way of doing business, and in countries where connectivity is also possible, we're seeing a number of judges that are also using online cases, online ways to actually address some cases. But the central question that was asked when we started the webinar was, how about the most marginalized? Are these cases decentralized to the most hardest to reach cases when we're talking about remote support for justice? And I think this is where the traditional systems or the alternative dispute resolution comes into place. And I think as civil society organization, we can really work very closely to ensure that our alternative dispute resolution channels are well known by children, first of all, in a child-friendly manner, and also really delving into the multidisciplinary approach where we can use child helplines. So our child helplines in Africa are cognizant of the fact that children are not accessing justice in Africa, and really ensuring that child helplines can also be that conduit with the justice system in terms of access to justice. So it's really encouraging to see that the justice sector has some response actions, but more needs to be done if it has to be accessible to children, particularly in having child-friendly justice or child-friendly information being circulated on radios or on TVs, or also on child helplines, and also legal aid societies really realizing the importance of ensuring that children access the justice. But also when we use the online, are we ensuring that there is a social worker that then has a debriefing with the child? So we know that in the normal traditional courts, a lot of African courts have also been investing in the use of CCTV so that the child does not really get into contact with the perpetrator. So how can we be more cognizant of these key issues in technology to ensure that the child continues to be protected as they're providing their evidence or as they're accessing justice? So the protection of the well-being of children within COVID-19 becomes a very important strategy. But I think one recommendation is for us to really come together as civil society with our governments and legal aid providers to really prioritize the cases coming before the courts that relate to gender-based violence, but also to the violations of children's rights. So I'm cognizant of time, Jenny. I'll stop here, but I'll be more than happy to share some of the justice sector strategies that have come out, particularly in preparation of the response action, but also recovery, knowing that COVID-19 might be here to stay for a couple of more months. Thank you.
So I'm going to allow Nkatha, but before Nkatha you come in, I can see Anne is back and her hand has been up for a while. And I want her to talk a little bit about, before you go, we continue with the conversation about COVID-19 and justice system. I just want her to talk a little bit more about justice system in Africa, and probably you can maybe mix it a little bit with COVID-19. Anne, you need to unmute yourself and switch on your camera. Thank you.
Hello, everyone.
Hi.
It's nice to see you all, and greetings from Pretoria. Yes, well, I think we've had a very interesting debate, and it's a very ambitious conversation to fit so much into one conversation. We've heard about access to children, or access to justice for children, perhaps more of a focus on child-friendly justice in criminal justice systems, and we've heard a bit about it in civil justice systems as well. But what I think is I would have liked to hear more about is how do we actually move beyond child-friendly justice, as important as that is, and think about access to justice, meaning can children actually stand up to fight, together with adults, of course, for their rights that go beyond the justice system. So let me give a good example that is linked to COVID. Let's say that a country decides not to reopen schools, but in fact the populace people think that schools should reopen. Could a group of children supported by lawyers and perhaps by NGOs go to court to force the government to reopen their school, or to force the government to put everything in place to make it safe for them to go back to school, including sanitation at schools where there are no toilets, for example? So these are the kind of bigger questions about access to justice, which I think is the next generation of thinking we have to do in Africa about how to use justice to access social justice for children. So that's what I've been thinking about, and I hope that others are also thinking about this and considering ways to take it forward. And some of the issues that you've been talking about with gender equity, for example, yes, some of those can be resolved on a case-by-case basis. Some can be resolved through law reform, but some might be resolved through litigation as well. So, and there are some examples in Africa of this kind of strategic litigation that I'm thinking about. And I'd be interested in hearing the views of some of you that are on the call about that aspect of access to justice.
Thank you, Anne. And then Nkatha for 30 seconds.
Thank you, Jenny. It was just a very quick rejoinder to add to what Yvonne said, and I now realize it's also related to Anne, to what Professor Skelton has just mentioned. And my issue was really just to say that I think COVID, as far as it's an emergency, as opposed to, not as opposed to, but in addition being a health crisis, but it is a form of emergency. And I think one of the things that has come from this crisis is that it has exposed how generally we are unprepared for emergencies relating to children. And my thinking besides, or in addition to what Yvonne was speaking about, is that we use also this moment to really question how much of our national systems, how much of our legal, the Act, for instance, the National Act, how much do we contemplate dealing with emergencies and knowing that when an emergency comes, this is how we are going to consult children, this is how we are going to prioritize children, this is how we are going to demand accountability on behalf and for children, particularly when measures like Anne was speaking right now are happening, such as decisions relating to education. What is happening in relation, to, for instance, to children not accessing vaccines? And who thought that was an issue? Was there any discussion, for instance? Was there a framework in place that allowed us to know that this is the test of reasonableness when it comes to, limiting the rights of children because we have an emergency? So I'm just saying that I think that one of the things that we ought to take out of this COVID-19 crisis, if nothing else, as far as access to justice is concerned, but even the broader context of children's rights is concerned, that we need to sit down and really seriously think about how we guide our action and response in times of crisis and emergencies for children. Otherwise, some of these issues would not have been as amplified as they are.
Thank you so much, Nkatha. So before we get our recommendations, we need to hear best practices. I'm sure it's not all gloom and doom when it comes to access to justice. We have some very good practices. So I'll start with Kenya, where I come from. I'm proud to be part of the guys who are doing an amazing job. Juliet, what are you guys doing to ensure that children access justice?
Thank you very much. And just to, sort of bring on what everyone has been speaking about putting the children to actually demand for their rights. One of the things that happened in Kenya a couple of years ago is the realization that really children's voices are not being heard within the justice system. And I happened to be in a discussion with what we call the National Council on Administration of Justice. And we brought on the conversation of what does justice look like for children? When we say administration of justice, what does that actually mean for children? And so therefore, the then Chief Justice gazetted what we call the Special Task Force on Children Matters under that National Council on Administration of Justice. It is one of its own. It's the first one, and nothing like that has been seen at least in Kenya. But I want to say that the activities and the things that we have been able to do as a task force are phenomenal, because unlike like we have all been talking about just now, where we placed policies, where we placed the laws on top of what everyone else should be doing, we asked ourselves practical questions. So we had a constitution that constitutionalized child rights. We had the Children's Act, and then we signed on to the UNCRC, the African Charter on Rights and the Welfare of the Child, and every other law you can imagine. But we realized that we also have a national plan of action. I'll mention that on the Children's Act. Yet we are not actually implementing. So we realized that the gaps, what we did together as a group is we sat down and looked at gaps and we looked at opportunities. Now, a lot of organizations, a lot of networks will look at gaps, and out of which, because I used to work for an NGO, I know, we look at the gaps and then we fundraise on the gaps and then we deal with those gaps, but then, or we do research and we find and we say, these are the gaps. As an academic, I'll probably do the research and say, this is where the gaps are at. But what we did as a task force is we went beyond the gaps. We looked at the gaps, we looked at the opportunities, and we looked at the solutions. So where do we strategize? Where do we put our solutions on? And we realized that if we actually used a bottom-up approach, it works best. Where you go to the children's remand home, for instance, and you look at the children and the state of the children, and you ask those children, what is it that is lacking? Why is it that you will find a child? Now, a remand home is where a child stays within the trial. The trial process of a child should not go beyond 3 months or 6 months, as the Children's Act stipulates in Kenya. But you're finding children in these remand homes. So why is it that the child is actually in the remand home? From which we understood that the child is seated in a remand home for about 1.5 years. because there is, there's delay in their cases. And then we also find out that we are waiting for a bus to transport the child from the remand home back to home, back to their houses, back to their parents. Then you also find out that the child who is in the child remand home does not have a lawyer. And then so we went back and asked the court, why is it that the child did not have representation in the first place? So we realized that though these laws are actually stipulated within, and the provisions are within our laws and the Constitution, they are actually, we realized that beyond that, there is need for regulations and guidelines, but broken down into practical things that people can actually do. And one of the greatest things I'll say that we did as a task force is when we started this process called Service Weeks, the Children's Service Weeks, where funded by various partners, including IDLO. We started looking at aspects of child protection. So we didn't just go in and say we need to rush cases of children. We need to have a service week within the week where we look at only cases of children, where we adjudicate on cases of children alone. We actually said, the court user committee, do you understand what child protection is? Do you understand who a child is? When a child is coming to court to testify, what are the mechanisms that we have put in place to ensure that that child is actually protected? The witness screens. But beyond the witness screen, does the prosecutor understand how to talk to the child? Now, that is breaking down the child-friendly justice system into something practicable. So we started training the prosecutors, we started training the magistrates, we trained the police officers in just how to deal with them. So within a week or within 3 days before the service week, we go in, we train all these people on how to handle the system, the children. So beyond the infrastructure, there is the actual practice of the justice system that we are actually fixing. So after we did that, we trained them, then we have the service week, and within a week, we are able to complete quite a number of cases. So what does that do? We have not only, finished cases of children and handled many cases of children, but we have actually changed a system, we have changed behavior, we have changed a process that took so long. From out of that, we decided to now document. And out of that, we came up with something called like the Service Week Protocol. So that's just one example. We used diversion to ensure that, in our laws, for instance, in Kenya, we do not have currently explicitly diversion does not exist. But we started discussing with the prosecutors, we started discussing with the children officers, we started discussing with the probation officers, how do we use diversion mechanisms and programs to ensure that children in the justice system actually are rehabilitated. And so the task force in Kenya has actually come up with a report which is available on the judiciary's website, which I'll be providing after this. And it shows about access to justice and the status of the child in the justice system in Kenya. That is what it's actually called. But it also now focuses on what the key institutions within the justice system need to do. Jennifer, you say this all the time, that when a child walks into the justice system, they leave the system as 5 different people. The child who walked into the police station is a different person by the time they're getting into the court, and by the time they're exiting the court, they're completely different people. And so what we discovered in our work is that we discovered that our system is actually broken. And so that is why even for us, as the lawyers, as the prosecutors, as the police, or whoever in the justice system, we're not seeing how do we help the child who is in the system as a whole, because even that system is broken in the first place. And the beauty of the task force is that when we all sit together, we actually make the child demand of us the best that we have to give, which is the spirit of the UNCRC. So that is one of the best practices I can actually say in Kenya. And I just want to bring in the conversation of, informal justice systems. Last year, we had a very interesting conversation when we were looking at developing our own diversion guidelines. So the DPP in Kenya, or DPP, have the diversion guidelines. But we were saying in our work that, look, there are so many children who, will do something that is in conflict or against the law, but they will never get to be reported to the police station. The chief will have to deal with them. The teacher will have to deal with them. So how do we bring in the informal justice system to actually handle these matters? Then how do we standardize that? And so one of the best things that what I would like to report is that one of the things we are doing as a task force is to actually develop this what we are calling a diversion toolkit. And the diversion toolkit will not just be looking at the formal justice system. It's also going to be really looking and standardizing all the processes that already exist within the informal justice system so that we can actually help and heal the child. Thanks, Jennifer.
Thank you. Judge Kome, I can see your hand is up. So I know you want to talk, but I want you to give you the closing remarks so that we can give you more time. So I'm going to go to Winfred. Winfred, give us your case study from Uganda and the best practices from Uganda. You're muted, Winfred.
Jenny, if I may, could Winfred also tell us the best practices that we can borrow from Uganda on how you're dealing with children during the pandemic? Because in Kenya, we've shifted to virtual courts, and we also know that the institutions are also taking in children as well. So how are you dealing with the COVID-19 and the courts and the institutions?
Thank you very much, Rosalind. I will start with your question. Unfortunately, when the Chief Justice of Uganda was coming up with standard operating procedures for the judiciary, the children were left out. So access to justice for children in conflict with the law was a challenge, at least for 1 month. What happened then was we engaged the judiciary through the ministry to divert these cases. And most of the because we do have diversion guidelines that were passed by the Inspector General of Police last year in August, and we encouraged police to divert petty offenses, because if we didn't do that, then the numbers would be, in the remand homes would be overflowing, because as we speak right now, they're beyond capacity. But nevertheless, what has happened is that the judiciary has adopted a case-by-case basis. So what happens is, once you agree on a date, with all the standard operating procedures in place, sanitizing, masks, you can actually take a child to court, because the process of setting up the virtual link will take a lot longer, and it will encourage and continue having a child stay in the remand home. So at one point, the remand homes were not receiving child offenders. Parents were being encouraged to come and stand as sureties for their children. So that way, there was a stopgap measure in place. With regard to the best practices in Uganda, what has been happening is, first and foremost, we do have a family and children court that is dedicated to handling all children cases, whether it is civil or criminal. There is a magistrate dealing with these cases. So you find that in terms of case management, these cases are actually fast-tracked. Now, of course, the only challenge will then be transportation, as I believe the previous speaker mentioned. Transportation is one of the biggest challenges. But what has happened is these cases are prioritized and must be concluded within 3 months. That is the standard that we're working with right now. And also in terms of best practices, the use of legalese, the use of wearing gowns and robbing, we don't do that in courts, because that way you get the children to open up, you get the children to engage, you get the children to participate in the whole process. And also now, especially at the level of High Court, I will speak about Kampala High Court. The judge then at the time, unfortunately, he has been transferred to another division. The practice was engage local community leaders, engage parents of both sides, because in his opinion, detention is a matter of last resort. So that way you saw a growth in jurisprudence justifying as to why. And we do have data that children that are given non-custodial orders tend not to reoffend. So the levels of recidivism are actually very low, as opposed to the children that do end up, incarcerated. So yeah, in Uganda right now, we're doing a dual system, both the formal and informal, and there's been a push. I will say the COVID-19 situation has actually been a blessing in disguise. We're seeing complainants using and resorting to more informal justice processes to have their cases resolved. That is the experience I can share with you all from Uganda. Thank you.
Thank you so much, Winfred. I was told Imam Ali from Bangladesh is here, and he wanted to give us his best practice from Bangladesh. For 2 minutes, kindly, Imam, for 2 minutes, just give us your best practice.
Yes, well, thank you very much for giving me the opportunity. I must say, whatever I've heard with keen interest from all of you has been so familiar from all over the world that I have visited, the countries that I have visited. It's all very easy to say, we want to do our best things for the child. What I would suggest is that keep in mind that the Convention on the Rights of the Child is the Bible. The comments coming after that are the guidelines, and if all countries follow that, they will have a good law. Now, having a law is not enough, because then you need to implement the law. Make sure that the people who are implementing the law are aware of the rights of the children. What is difficult is the mindset of the people who are the actors in the child rights field. And I think I agree with exactly with what Winifred said. But then, having heard Juliet, I understand that Kenya is now on a good path and doing good things for children. What I would suggest is that if you look at the last comment, the CRC General Comment number 24, you'll see that that requires all the actors in the child rights field to be trained. And I think that is the important aspect. You have to train people. Our mindsets are different when it comes to children. We do not treat children as they ought to be. Unfortunately, we don't have the respect for children as, first of all, as human beings, and secondly, of people having rights. Children have rights, and we seem to overlook that. And the other thing that is most important, I would say, is that the Convention in Article 3 gives the key words, the best interest of the child. If whatever you do, whichever way you treat the child in court, in your decisions, if you keep the best interest of the child in mind, whatever you are doing, is it in the best interest of the child? And then I think you cannot go wrong. So respect for the child, best interest of the child, and child, of course, can and must be heard. Article 12 tells you that. Now, I want to very quickly tell you what we did during the COVID, because that is what I promised to say. What happened was our courts were not sitting, our parliament wasn't sitting, we did not have the laws in place to have virtual hearings. So I chair a committee called the Child Rights Committee in the Supreme Court. We somehow managed to get an ordinance passed through the president of the country, whereby virtual hearings were allowed. But then what happened was nobody knew how to really operate it. We didn't have the equipment in place. With the help of UNICEF, we got the equipment placed for the children's homes as well as for the courts. Then what we did, we trained everybody almost overnight to how to use the system. Next morning, I expected everybody to let the children out of the centers, because the children were overcrowded. The space was for 600 children. There were 1,140 children in the 3 development centers. What happened the next morning? I asked in the afternoon, in the evening, how many applications? 1. Why? What happened? So next morning, I have a meeting with all the judges over Zoom. What happened? Nobody made an application. So I had to give them a piece of my mind. I said, in which law does it say that an application for bail has to be made? If a child stands up and says, please let me go home, that's an application. And from then onwards, things happen like magic. In the space of 7 days, we released 343 children. Up to now, we have released 421 children from those homes. So it can be done. It needs the willpower, and it needs the want to help children who are in a difficult situation. They're away from home. We are in an emergency situation. The COVID is threatening all of us, most of all children. And that was how we managed it. I hope it helps some of you to deal with the situation. Thank you again for giving me the opportunity.
Thank you, Judge Imam. So finally, Honorable Justice Martha Koome, sorry for keeping you waiting for a while. So I know you lead this amazing team, and as you finalize and this conversation before we go to the Q&A, what are your final words regarding best practices on juvenile justice system or child-friendly justice system?
Oh, thank you very much, Jenny. Thank you, Mtoto News and IDLO for convening this amazing webinar. In fact, I have learned a lot from colleagues from all over Africa and even Pakistan or Bangladesh. I have taken so many notes on many things that will add value to the work that we are doing. Juliet has spoken to what we have done as the National Council on the Administration of Justice Special Task Force on Children Matters, which was put together to bring all the actors in the administration of justice to address the issue of access to justice of children and to look into the entire well-being of the child. That is also looking at the registration, the Children Act, to see whether it is comprehensive enough to protect children, to look at the rules of procedure, to look at the policies and all the practices. And like everybody has said, the biggest problem is not the law, it is the implementation. I was privileged to serve as a committee member of the African Committee on the Rights and Welfare of the Child. And our main agenda then was to ensure that there was harmonization of laws all over Africa, so that we can all read from the same script when we are talking about a child. We understand the child is anybody below the age of 18. And then we can build all the mechanisms to protect that child by eradicating all the evils that before a child, like early child marriages, FGM, and everything you can think about to protect our children. And I'm happy about the celebration of the Day of the African Child that is set aside every year to remind us that children are the greatest stakeholders that we have. They are center to all the things that we do, be they issues of democracy, be it the rule of law or respect for human rights. Our children are center because they partake all that. We have a responsibility to protect and promote their rights. When it comes to accessing justice for children, I've had issues of concern about participation of children who are excluded because, they are considered, because of their age, to be either incompetent or not to have a voice in the decisions that are being made. But what I can say is that under the Constitution and even UNCRC and the African Charter, the participation of a child is provided there. It is critical. And speaking for myself as a judge, and I also I've been a judge for many years. I was a judge in the High Court when I was doing some adoption matters. Now I sit in the Court of Appeal. But even then, when I was doing adoption matters, which is the only matters that come to the High Court for trial, I always spoke to the child as long as the child was able to speak. Even if the child was 3 years and were able to speak, I would have to speak to the child and ask them, even if it is simple questions. Do you know the person who is holding your hands? Where did you sleep? What did you eat? Would you know where you are? You have to engage the child. And if the child has got the necessary intelligence, They will tell you so many things that you may not even know from the documents that are before you. So the take home from this webinar should be, in every decision anybody is making about a child, the child must be involved. It is their fundamental right that you cannot take away, that you can actually seek their view before you make a decision. So moving forward as Africa during this COVID, I have also learned a lot about making decisions that affect children without their involvement. And I've heard the concerns raised by many that decisions were made to close schools and children were not consulted. And as the pandemic proceeds, we have come across very many cases of child abuse. Indeed, in Kenya, there is a spike of child abuse cases. And the question we are asking is, who is abusing the children? The children are at home. They are supposed to be among the members of the family and the communities that love them, that should protect them, that should provide for them and shield them from any harm. How come we are having a spike in child abuse cases and in worst forms of abuse, defilement cases? So I like what everybody has said here about community involvement when it comes to building systems, mechanisms that protect our children. We must involve the families, the local communities, for them to first of all understand it is their responsibility to protect a child. Recently in Kenya, a public officer called a DC went viral on social media because he was addressing local leaders, and he told them, if I will ever hear of a case of a child who has been abused, defiant in this community, I will arrest the chief and I will arrest the police officer in charge of that jurisdiction where the child has been abused. If the child has been impregnated, it is them who will be charged with defilement before they could find the person who defiled the child, because they should know the children within their jurisdiction and they should monitor them and protect them and safeguard them from harm. So this is the message I am taking during this celebration of the African Day of the Child 2020, that it is the responsibility of all of us, the community, to ensure we protect our children, and the justice that we give our children begins with ourselves. How are we treating our children? Because justice is not just the formal justice that you get in the courts. We have said in Kenya that appearing in the formal justice system for a child is a matter of last resort. All children must be dealt with through diversion, through the communities taking responsibility for their own children and families taking care of their own children. I think, Jenny, that's all I wanted to say, and thank everybody for your very, very good contributions to this discussion.
Thank you, Judge, and thank you for all your support that you have given the work of children. So I've seen we have lots and lots of questions and answers. So Rosie and Shiro, I think we have like 5 minutes for the questions. I can see hands not coming up. Thank you for lowering your hands. Apart from Eric, who is a child, who I'm going to allow to ask he's gone again. Rosie? Oh, we lost Rosie.
I'm right here. Yeah.
The question, the Q&A.
Okay, so the first question I'm going to read out is from George Wanyonyi. He's asking, how can we all endeavor to strengthen the monitoring systems that would guarantee access to justice for all children? This is particularly in the face of reducing government support to monitoring agencies, such as the National Gender Inequality Commission, and increasing threat to merge some of them, e.g. National and Gender Equality Commission in Kenya and the National Commission on Human Rights in Kenya. So, Judge, would you like to answer this question? Justice Kome, we have two judges here. Justice Kome.
I saw she was having. Okay, she's there.
Yes, say it again, Rosie. I didn't get all of it. I was having some technical issues here.
Okay, it's about monitoring systems. It's asking, or George is asking, how can we all endeavor to strengthen the monitoring systems that would guarantee access to justice for all children? This is particularly in the face of reducing government support to monitoring agencies such as the National Gender Inequality Commission and increasing threat to merge some of them. For example, the National Gender Inequality Commission and the National Commission on Human Rights in Kenya.
Okay. Thank you. I think first and foremost, every institution of justice should have its own monitoring and evaluation system that records and tells us the cases of children in their system and how long a child has taken in the justice system. Because I do not think that this can be done appropriately by an institution outside the justice system itself. For instance, judiciary must have its own tool of monitoring the cases before the Kenya Human Rights Commission or the Gender Commission can come to monitor us. We must be able to tell everybody, because we are accountable, that these are the number of children who came to court, this is how long they took, and this is how we process them. And this is where it was realized that judiciary alone cannot ensure access to justice for children without collaborating very, very closely and working hand in hand with all the other actors. Because if they delay on their part, we call it a chain link, or what Juliet was referring to as a broken pipe. If there is some breakage somewhere, then it will affect everybody. The chain is as strong as its weakest point. So the police must be up to scratch. The prosecutor must be up to scratch. The children officer must be up to scratch. The probation must be up to scratch. Then the monitoring institutions of human rights, like the Gender Commission, can come in and find where we are not performing properly, and they can help us with more ideas on how we can improve. For them, they also need to be monitoring, because we are waiting here for cases to come. But cases are happening. So many cases of abuse are happening. They are not being reported. That is where they need to sharpen their skills in ensuring that in the communities, they empower the communities to understand about abuse, child protection, and the reporting mechanisms from the community. I know he has also mentioned about the role played by all these human rights commissions that overlap. But I don't think it is for me to respond on that, because I think that's a major policy issue that requires Parliament, because each body was created with its own mandate. If there is a need for them to be merged, it is for Parliament to decide. Thank you.
Thank you, Judge. There's another question by Milan Kabata, that's my sister. And she's asking, the common Mwananchi is often worried about the cost implications anytime they hear justice. What campaigns are available on the ground to support the child who needs these services? Mwananchi, for the non-Kenyans, our fellow Africans, means an ordinary person. That's what we call an ordinary person in Swahili. So a Kenyan citizen, that's what we call each other. So Dr. Nkatha, in South Africa, what are you doing to ensure that legal representation is offered in a way that people can afford it, in an affordable way?
Thank you. Though I have to say, really, I don't purport to speak for South Africa, because even though I am based in South Africa, we work on a regional level, and I think there are people who are best positioned to speak on, access to justice in South Africa more specifically, especially if Professor Skelton is still here. I think she would do a better job than me. But I think I can speak from a more regional perspective, because that is what I have worked on, and maybe also beyond South Africa, somehow related to South Africa. And because we are speaking in relation to children, I would say that one of the greatest successes of enabling access to justice for children has been the work of NGOs that are able to support legal aid or to provide legal aid to children. Because even when we rely on the legal profession itself, when we rely on the law associations and in the various formations that they come at national level, those access to justice, those legal representation platforms don't actually sufficiently, reach out to all the children. And quite frankly, legal aid does not prioritize legal aid to children. So obviously, one of the main requirements, or one of the ways that we can make sure that children are able to access justice, is to ensure that legal aid is available as a matter of law, which I think one of the commendable things that has happened across the continent is that most of the Children's Acts or Access or Justice, Child Justice Act now do integrate an element of, requirement of provision of legal aid to children. So that is one. But two, I think, as Justice Martha has spoken, but also I think previous speakers have said, we need to have a conversation on this continent on, deconstructing the elitism that comes with justice. Just the word justice sparks a certain kind of exclusivity to the regular person on the street. And it makes it look like it's an exclusive club that is, accessible to the lawyers and to people who have the resources to access it, which it shouldn't be, because in any country, a justice system is supposed to be, the place where every regular person can feel that they can go there and find justice. Unfortunately, for most of our African countries, courts are the last place you want to go, because if you go there, you're sure that by the time you get heard, it's next year or the year after. For children, we don't have that luxury, because children only have 18 years to be children. If you're wasting 1 year of a child's life, as I always say, you're taking about 5% of their childhood every year that is delayed. So we don't have the luxury of saying that the justice system, the justice process should play out. So my view is that we need to have mechanisms that can very quickly, cut back on the amount of time that takes. In some countries, it's being done by, one facilitating, very effectively facilitating diversion programs that, in the first place, like we say, don't allow children to have to endure this process, but also just ensuring that if children do go through this process, one, that we don't limit their experience of life as they wait for justice to be delivered. So don't keep children in remand homes unless they really have to be. So, they can continue with life while the process is still going on, and when the decision is made, you can find other ways, because really children don't run across the borders. It's very easy to find out where the child is if the child is indeed in a position that you need to access them. This is really a question of mindset, that we ought to not think of children as criminals, but we ought to think of children as people who need correction and who need support to come back to regular life. The second element, very quickly, is the element of access to justice in the sense of strategic litigation. And I think that is one element we haven't spoken enough about, or we haven't really spoken a lot about here, and which I think we need to pay attention to. Strategic litigation in the sense of some of the issues we are raising here are systemic, and we can address systemic issues through strategic litigation that then gives us a remedy that we can apply to all children, or at least to a lot of children at the same time. So we don't have one child, every time a child is violated in the education system, they have to come back. We need to also cultivate that culture. It's working very well. The Center for Child Law here in South Africa has done a marvelous job of strategic litigation within the South African context. I think we can replicate that in other countries. We haven't as successfully. In some countries, yes. In some countries, no. We haven't done that as successfully. The last thing, obviously, is what I started with, which I said, local solutions, community-based solutions will always be there, whether we like them or we don't like them. So the sooner we can make sure that those mechanisms are working for children, I think that is one of the ways in which you can facilitate faster justice, faster resolution of issues for children so they can move on with their lives.
Thank you, Dr. Nkatha. I think in Kenya, we're also having that problem that children are going through the system without legal representation, even if it's in the law. So I'd like to take this opportunity to encourage the magistrates and judges to make sure that no child will go through a case till the end when they don't have legal representation. Also, we have a gazette notice in Kenya where there's a pro bono scheme for lawyers where they can be paid a stipend to handle each matter for children. And I think most lawyers don't know about this. So I'd like also to call on to the Law Society of Kenya to make sure that each child has a legal representation as they move through their cases. I'd like to welcome Shiro Mugeni to ask the next two questions. Please bear in mind we have another engagement at 6 p.m. So maybe let's take the shortest time possible to conclude. Thank you.
Good evening. The next question is, to what extent is access to education for children in rehabilitation and remand institutions attained in Kenya? This is a question from Emma Kimenchu. To what extent is access to education for children in rehabilitation and remand institutions attained in Kenya? Perhaps, Madam Juliet, you can respond to that.
Yes, thank you. Unfortunately, one of the things we found out as well is that, of course, when the child goes into the remand home, because it's meant to be a temporary placement, it's not supposed to be, the child is not supposed to be there permanently. We discovered that there is actual little to no education in the remand homes. And one of the things as a task force that we pushed for, and we really are imploring and asking the Ministry of Labor and the Ministry of Education to come together and come up with programs that are going to support children who are in the remand home, because as we have agreed and as we have spoken here, children do spend quite a lot of time in the remand home waiting for their trials to go on. And so one of the things we encourage is that we come up with some sort of education for the children, or some form of learning for the children to partake when they are actually in the remand homes. In the rehabilitation centers, however, the children do, because at the rehabilitation centers, the children are supposed to stay there for about 3 years. So there is primary school education, and so at least there is some level of learning, and also not just that, but there also vocational training that happens in the rehabilitation centers. So there is some form of formal learning that goes on in the rehabilitation centers. Thank you.
Thank you so much, Juliet, for that quick response. Finally, there's a question from Tai Kalem. Access to justice for children includes the right to protection, the right to effective remedy. How does this work in terms of a plural legal system? And have the interplay of different rights, because we're looking at access to justice, but how do we ensure that the other rights of a child are also respected while they're going through the justice system? We can have, sorry. Banani? Do you still have Banani to respond to that?
Banani is an interpreter.
Oh, sorry, Elvis.
So
Are you with us? Okay.
Yes, I am. I'm right here, and I would like to concur with what Nkata said earlier about the issue, because there are two things involved. If you encourage or protect or encourage a child's right to access justice, there are other rights that could be violated in order to achieve that particular right. But in some cases, and I will always link it to some of the work that we've been able to do over the years, is the fact that in most cases, when parents or when adults do allow children to access justice systems, they usually do that in times when they know for a fact that the outcome of that decision could be in their own interest or could benefit the adults in that case. But to ensure that there is no violation of other rights, and that is why we have the term child friendly, the word friendly is added to it. And the fact that it's a justice system that could allow children, and I'm happy that I got an example from, I think, Uganda, where they said don't wear robes in courts, where the system allows the child to air themselves or to express themselves freely without any interference from anyone. And that is something that we need to do, because if you want to protect a child's right to participate in a justice system, you need to give the child the leeway to be involved without interference. And then you give due weight to the views that have been expressed at that particular instance. But in terms of the plural justice system, I think Nkata had a very good and persuasive argument in that case, which I think I will pass that on to her to repeat maybe what she said without me duplicating what she mentioned, which is a very good argument.
Thank you so much, Elvis, for your feedback. And I'm sure we had a presentation from Nkatha, which is recorded for reference. But basically what as a concluding remarks, I'm looking at perhaps it will be prudent for us to look at what are the challenges that children face in each and every category they interact with the court. If a child is a complainant, if the child is the offender, if the child is the victim, maybe we need to diversify different strategies on how to approach, to deal with children who are engaging with the courts in different entry points. The other one also, as we conclude, I wanted to ask is what are the indicators we're monitoring? This also came out from Judge Kome, that we need to identify what are we monitoring. Is it structural indicators, process, or the results that we want to see at the end of the day? So that as juvenile justice actors, we're able to know that this is what we're going to refer to when you're criticizing the juvenile justice system, or maybe the judiciary, or maybe the police. What are the indicators that we're going to look at to ensure that these processes or the systems and infrastructure are friendly to children and are basically enhancing child-friendly access to justice. As I conclude, I would like to hand over to Roslyn. Roslyn?
Yes, I think we are done with the questions.
Yeah.
If there's anyone who needs to ask us questions as the NCAJ Special Task Force on Children Matters, please send in your messages and questions to stfcsecretariat@gmail.com. stfcsecretariat@gmail.com, so we can answer your questions. And for the rest, I don't know if you want to give out your contacts or how people can reach you. I'll give the panelists a second each to tell people how they can be accessed. We start with Elvis. Your mic is okay.
Okay, yeah. So for me, I'm sure, what should I say? How to get hold of me?
Yes.
My email, I think, is very visible on many platforms. It's efokala, as you see my name, @gmail.com. I'm based in Stellenbosch in South Africa. And yes, I do some research on children's rights, and I still learn a lot about children's rights. Thank you.
Great. Any social media handle?
Yes, I'm on Twitter, I'm on Facebook, I'm inactive, I'm on Instagram, but I've not been there for 4 years. And yeah, so thank you.
Okay, Yvonne?
Thank you, Roslyn. You can get hold on me on Yvonne.Tagbire, just as it's spelled, at gmail.com. On Facebook, I am Gamu Tagwire, GAMU. And I'm really keen on really also addressing the issue of children with incarcerated parents. I think there was a very pertinent question on how circumstantial children are dealt with that came from Zambia. So Hemis, please reach out, and then we can really try and unpack access to education for circumstantial children. Thanks.
Okay, thank you. Edmund?
Thank you. It's easier. Just look for Foley, EFOLEY, at ihrda.org, Institute for Human Rights and Development in Africa, ihrda.org. Social media, you find me on Facebook, Edmund Amakwe Foley. I have a picture with me in a bow tie, so that's me. It's done deliberately, yes. Yes,
okay, and what country are you from? So
I'm
that
from
if
Ghana. Yes, I'm from Ghana originally, but I live in the Gambia.
Good, okay. Winfred? Your mic is muted.
Sorry, I'm very inactive on Facebook and Instagram. However, I can be reached on via email, W for whiskey, dot adukule, ADUKULE @gmail.com. And for more information about Free Child Uganda, we have a website, www.freechilduganda.org.
Great, and Winfred, you're from Uganda?
Uganda, yeah.
Yes, anyone else have left out? Dr. Nkatha?
Yes, well, I am at nkatha.murungi for both Gmail and UP at up.ac.za. That's the University of Pretoria emails. You can find a bit more information on the Center for Human Rights website at the University of Pretoria. Yeah, on Twitter also as Nkatha_Murungi. Yeah, if you can reach out to me on email, I think that's the more easily accessible medium to me. Thank you.
Thank you. Juliet?
Thank you. I actually put out my email address on the chat section, so you can find it there, but it's simply juliet.nyambura, NYMBURA, @kabarak.ac.ke. Thanks.
Great. And you're from which country?
Kenya.
Okay. I think I haven't left anyone out. Justice Iman, would you like to give us our closing remarks, or Justice Kome, anything you might say as we close, and that will be the last word. When the judge speaks, that's the last word. Justice Iman, if you have something to tell us, and Justice Kome, and then we can close and leave.
Well, all I can say is I am very grateful for allowing me the time to say a few words about Bangladesh. If anyone wants to contact me, I've given my details in the chat box, so you're most welcome at any time. If you want to know more about Bangladesh, how we deal with children here. The interesting thing about the question on legal aid for children, we have the law in place which says that any case, any trial relating to child cannot go ahead unless and until there is a lawyer in place to represent him. And it will stop as soon as a lawyer isn't there, another one is appointed, then it will go on. So, you know, these are things you can put in a law, but then implementing the law is the difficult part. It's a question of overseeing, monitoring, and our Child Rights Committee in the Supreme Court, we do that. And I like to think that we try our best to get the best results for all the children in our country.
Thank you so much, Judge. Thank you so much. We are glad you joined us for this webinar. And I'm sure we'll be contacting you for more information. Justice Kome?
Thank you very much, all of the organizers. I think the COVID-19 emergency has some silver lining in it, because a meeting like this would have involved us all being transported to appear in one place like South Africa, Kenya, or Ethiopia to discuss the many issues that we have discussed about children. So we should see how technology can be used more to share these experiences so that all of us speak one language of child protection, of empowering the child to become an agent for themselves, so that when they are abused, they are able to report, they are able to use these call numbers, emergency numbers that we have been given. I think in Kenya recently, even the Department of Police came up with a hotline so that children can report abuse, but we need to empower them to become agents of their own protection. So thank you everybody for joining us to celebrate the Day of the African Child. God bless you all. We stay together.
We do. We stay together as Africa and as Africans. So let's celebrate the Day of the African Child. Let's celebrate African children. And we hope that we can have more engagements about children, access to justice in the pandemic especially. So we'll organize that next. So now we are moving on to 6 p.m. We'll be with official Janet Mbogwa at official Janet Mbogwa on Instagram. If you want to continue this conversation and hear about the child justice system, please follow her, and also follow Judge. Her Instagram handle, she has an Instagram handle, it's at Martha Kome. Please follow her and follow the conversations, and also Mtoto News, which is at Mtoto News. And then listen in, learn, and celebrate an African child. Thank you. Bye.
Thank you. Bye.
Thank you, everyone.
Thank you, Rosie, in our wonderful facility.
Cheers.
Thank you, Judge.
Everyone stay safe.
Bye, Edmund.